Welcome everyone to this British Property Federation webinar, What Next for the Landlord CVA? From its origins in 2009, the Landlord CVA enjoyed a pretty unchallenged run for nearly a decade. And then came the first court challenge, the Debenhams CVA in 2019, closely followed by COVID and the resulting flood of Landlord CVAs in the second half of 2020. And those CVAs seem to have finally spurred landlords into challenge action, because in the past few weeks, we have had a small flurry of CVA court decisions. In particular, we've seen the New Look challenge and the Regis challenge, but also a court decision on a different sort of restructuring affecting landlords in the Virgin Active gym fitness chain. And there are a pipeline of others still going through the courts. It's probably fair to say that most of the decisions have not produced the outcome landlords were hoping for, but they do contain a lot of detail, and it's important to understand what that means for the next phase of tenant restructurings that is surely coming as we slowly emerge from the pandemic and restrictions are lifted. And I'm particularly mindful of the supposed cliff edge date of 30th of June, when the legal restrictions on landlords are supposedly going to be lifted, unless of course there is a government change of mind. So the objective for today's webinar is to unpack these decisions and provide some practical advice on how landlords can best position themselves for what is coming down the road. I'm Inga West. I'm a counsel in Ashurst's restructuring team, where I specialise in all sorts of insolvencies and formal restructurings, including advising both landlords and tenants in respect of landlord CVAs and restructuring plans. I also chair the Insolvency Lawyers Association Technical Committee. I'm delighted and honoured to introduce my very prestigious and experienced fellow speakers. Ladies first, Julie Gattegno is a solicitor and a real estate disputes partner at CMS, where she leads a dedicated insolvency team within the real estate disputes and is a member of the BPF's Insolvency Committee. She has acted in relation to many landlord CVAs, too many to mention them all, but recently they include Debenhams, New Look and Nero, to name but three. Richard Fleming is an insolvency practitioner and managing director of Alvarez and Marsal Europe LLP. Richard has extensive experience in restructuring across a wide range of industries, and particularly relevant to today is the man credited with launching the very first landlord CVA in 2009. Most recently, he's been involved in CVAs proposed by Pizza Hut, All Saints and LK Bennett. Simon Moscow is head of asset management for UK real estate at Aberdeen Standard Investments and is responsible for a number of joint venture partnerships at Aberdeen Standard, and also overseeing the performance of assets on behalf of a number of clients. Simon regularly encounters landlord CVAs and has recently had involvement with the Regis Challenge. Simon is also a member of the BPF Retail Board. So to get us started, Simon, can we look for a landlord view on CVAs, a brief one? Can you tell us what, if anything, you like about landlord CVAs and what you dislike about them? And anticipating there's probably quite a lot you dislike about them, perhaps you can give your view as to why it's taken 10 years for landlords to bring these challenges before the court.
Yeah, thanks, Inga. I won't surprise you. I'll start with what I dislike about them. I think I'm going to use the word fairness. Landlords, I believe, are treated unfairly. When a CVA is passed with 75% creditor approval, and it's the landlord usually is the only creditor that's significantly impacted, and this is done by vote swamping. We start from my position. Over 70% of retail and leisure space is owned by charities, local authorities, pension funds, and there's a sense of misuse of CVAs at the moment. I respect where the legislation started and its original intent. I'm deeply concerned, as I suspect others will be, the stream that we saw 2017, 18 and beyond, where we suspect that number of CVAs weren't fair and the actual legislation was potentially being misused. I go back to, it undermines the lease contract. A CVA gives an unfair advantage to the business against those that aren't CVAing. I've used the word, I'm careful, I've used the word misuse. I'm thinking about manipulation of votes, unaffected creditors giving votes, lack of oversight, potentially, a permanent rewriting of contracts. We enter into these lease contracts, but both parties openly, fairly, eyes wide open, a lack of transparency. So where where I'm disappointed with CVAs is, for our experience, where we're often told, if you don't like it, you've got the break. When we have served the break, disappointed to hear back from the tenants, actually, we want to stay, we can revert back to the original lease term, the original rent. That's disappointing. It's disappointing when 6 months after a CVA, you receive requirements from that same occupier. It's disappointing when we're seeing third or second CVAs from occupiers. You know, one wasn't enough, they've had to go again. So I go back to my point about unfairness. Landlords' claims discounted at 75%. I think Regis has put that to bed. Rents are reduced for the term of the lease, not just the CVA. Again, that some of the case law will change that. Restrictive landlord termination rights. The list goes on. I will end on very briefly for time. You know, what I like. You know, Richard's going to talk about the origins of the CVA. Clearly, if it's there to prevent, if the alternative is admin insolvency, and it genuinely is, then I understand the need for a CVA. This is a partnership. If we can, you know, we can help a business continue. We don't want to see anybody fail. Very briefly, you asked, you know, why is it taking so long? You know, I think it was the original. We go back to the original use of a CVA, and there was support from landlords because we genuinely believe the alternative was admin insolvency, which nobody wants to see. Fast forward then from the original time of 09, 10 to 17, 18, 19, we're having to explain to clients these are coming through on such a regular basis, and it's the landlord that is picking up the bill, picking up the cost.
Thank you, Simon. Well, that's what you're up against, Richard. If we could perhaps start by looking at New Look. So just a brief recap. New Look was a clothing manufacturer with over 400 stores. Its business was heavily affected by the pandemic and the resulting compulsory store closures through COVID. It was forecast to run out of cash in October 2020. It proposed a CVA in August 2020, combined with a wider restructuring, a wider financial restructuring, pursuant to which the shareholders were all but wiped out and the senior secured note holders were heavily compromised, pursuant to a parallel scheme of arrangement. The CVA contained the now familiar terms compromising categories of landlord arrears and future rents, imposing severe rent reductions in the form of turnover rents. A number of landlords challenged on several grounds, but their primary challenge can be summarised as arguing that it was essentially unfair to use unimpaired creditors to vote down the impaired landlords, the supposed differential treatment argument. And this argument failed. So Richard, can you help us to understand why this argument failed, particularly in light of Simon's complaints about the CVA? Why did the New Look challenge fail? Why wasn't it unfair?
One of the main concerns that landlords have expressed to me over the life cycle of CVAs, literally since 2009, I would characterise it as, why are you just picking on me? Right, that's really been the key tenet, and I think the key. And why aren't you picking on other creditors? Why is it the landlord, to use Simon's words, that are picking up the bill? And you know, and actually, I do share the concern, as given that I was hearing that in 2009, 10, and 11, as why has it taken 10 years for something like this to be tested? Right. So, but the argument failed. Because actually the judge looked outside of the CVA to see what else was going on in the business, because the CVA really is only effective for what I call the operational restructuring of the business. What often needs to happen in parallel to that is the financial restructuring of the business. And actually in New Look, that's what was going on. There was a wider restructuring. The equity was being all but wiped out. The debt was being and there was $1 billion, if you like, of debt in this business that was being very significantly compromised. And that was being done via a debt for equity swap that was being consummated via a scheme of arrangement that was running in parallel to the CVA piece. So you had lots of compromises and lots of pain being taken. It's just that was being taken outside of the CVA. So why was that? It's because actually the CVA in its legal construct doesn't allow for a secured creditor to be compromised or equity to be compromised through the CVA mechanism itself. That has to be done either consensually outside the tent or outside the room, or in reality it's done via a scheme of arrangement, which in of itself has its own tough voting hurdles that have some parallels to CVAs, and that you need 75% approvals for that to happen. So a lot of pain was being taken, and so in essence, the judge made it clear that the different treatment between different unsecured creditors is not of itself inherently unfairly prejudicial, provided it's being done for commercially justifiable reasons for business continuity, right? And I think that's the really important piece here. So, and as someone who works extensively in this field, this whole case was a test case for lots of the points of concern that landlords have expressed to me over the years, and which I have sympathy for. But the court is really, in respect of a lot of those points, has really put it in the basket of there's nothing to see here, right? And really they've gone to validate what has been market practice over the last 12 years. Now, I know that's not a pleasant scenario, and I appreciate, because actually, you know what, in all the restructurings I get involved in across all the industries I work in, no one likes losing money, no one likes having to compromise, no one likes having pain. But actually, it's the CVA it's a commercial bargain that has always suffered from a lack of judicial decisions, and actually New Look, if nothing else, is helpful, because what it has done is given the stakeholders in and around this mechanism, from retailers to leisure operators to landlords and others, just more clarity.
Thank you, Richard. And Julie, I wonder if you want to just sort of come in there, particularly because it wasn't all completely bad news on the sort of vote swamping arguments in New Look. There was something sort of hopeful for landlords, wasn't there? Do you want to sort of comment on the vote swamping comments in that judgment?
Yes, thanks, Inga. Yes, I think the key takeaway for landlords in what was probably otherwise a disappointing outcome was the comment by the judge that there would be strong grounds for a CVA to be unfairly prejudicial, where the votes of unaffected creditors swamped the votes of those who were impaired. So I think it does obviously depend on the circumstances, and the facts here was, as Richard's just said, there was commercial justification for the differential treatment between the creditors. But I think in other cases, looking at how the votes play out following the CVA creditors meetings is going to be really important. And I think that's the sort of key takeaway for landlords, that there is something there for them to look at.
So if they're being vote swamped by truly unimpaired creditors, then there's it's likely to be unfairly prejudicial. It just wasn't that scenario in New Look.
Yes, and I think what they said, it wasn't necessarily inherently unfair, and in that particular case, on the facts, it wasn't found to be unfair. But in another case, even with objective justification for differential treatment, the judge said there would be strong grounds to conclude unfair prejudice.
Super, and thank you. If we can stick with you, Julie, if we can have a look at the Regis case. So in Regis, which was a hairdressing chain, there was a different result. So Regis, a hairdressing brand, proposed a CVA in 2018, long before COVID. It was an older style CVA. It did contain the usual landlord categories and compromises, but it kept whole, in particular, and crucially, it kept whole two critical creditors, as they called them, one of which was its sole member, sole shareholder, IBL. And this was a case where the landlord's challenge actually succeeded, because the judge held that IBL should not have been treated as a critical creditor, should not have been kept whole. Keeping this intercompany creditor and sole shareholder whole was unfairly prejudicial to the compromised creditors. Striking down the CVA, the Regis CVA, was, however, something of a Pyrrhic victory, since Regis had long since gone into administration and the CVA had been prematurely terminated, a fate suffered by approximately half of companies that proposed CVAs. But that's a different issue, one for another time. So in the Regis CVA, this only really left an argument about the nominee's fees. But still, the outcome, the successful striking down of CVA, represents something of a milestone in the development of CVA challenges. And so, Julie, can you explain why the landlord's argument succeeded here and in Regis when they didn't in New Look, and whether there are any sort of general points we can draw from this? And perhaps actually you've covered some of them already, but if you can, what else is there to pull out of the Regis decision?
Yes, well, I think in Regis, the facts of the case obviously determined the outcome there. It was clearly a very different situation where, as you've just said, the Regis treated IBL, its sole member, as a critical creditor and a creditor that it was going to pay in full. Now, it was doing that at the expense of the landlord and other unsecured creditors, and there wasn't commercial justification or any justification for that treatment. And I think that really contrasts with the New Look position, where in New Look the secured note holders were impaired. They were, as Richard said, swapping debt for equity. The creditors in New Look were the creditors weren't taking any. There wasn't any CVA assets available for the unsecured creditors that would have been available had they not compromised the secured note holders. So it was a very different situation where the secured note holders in New Look were being compromised, compared with the situation in Regis, where it was a completely unimpaired creditor that they had treated, who was a sole member of the company. And basically what they'd done is elevated the position of the shareholder, who was the sole member who was going to receive the payment, the full payment of their debt in the Regis CVA, above the rights of the unsecured creditors.
Thank you, Julie. So the key takeaway then is to look out for what's going on with the equity and any subordinated creditors then in when you're looking at CVAs in the future.
Yes, I think so. I mean, in this case, as I said, the IBL as a member of Regis was a sole member, and they were receiving preferential treatment that wasn't justified. It's necessary to look at the position of all subordinated creditors and equity to see exactly what's happening in the CVA and the wider restructuring, to determine how is the company treating other creditors.
Thank you. So let's move on to this termination right, which Simon mentioned earlier. So once we get beyond, if we've established that the impaired creditors are not being unfairly voted down by unimpaired creditors, it then turns to the deal they're being offered and whether that's fair. And it seems to be the test is, well, if they're given a termination right, the court's very reluctant to look very closely at what the deal is on offer. They've got a choice to accept the termination right and get off the bus, or accept the proposed deal and stay on it. Beyond the existence of the termination right, so the court's really not going to look very much further. So this is a question for sort of Simon and Richard. Are there now sort of any minimum limits to the deal that tenants can offer landlords, provided they include a termination right? Richard, if you want to go first as to what you think that the law says, and Simon, perhaps we can hear what your sort of response to that is as a landlord.
Yeah, thanks, Inga. I mean, a couple of points I'd just make first is that actually just going back to what Julie's said about the Regis decision. I mean, I have to tell you, as a restructuring practitioner, I'm delighted by that judgment, right? Because I think it's 100% right. I mean, I'm certainly not a fan of that CVA in terms of the construct that was put forward. And the other thing I would say is I'm also pleased about the reinforcement around the voting dynamics on New Look. But what I would just offer this community is that the vast majority of CVAs that I've done have been absolutely dependent upon the landlord vote, right, to actually to be approved. It's not in every case, but the vast majority of them have done. So that is a dynamic that we find in our market. But so termination rights, I mean, they found their way into CVAs actually on the back of landlord feedback and actually engagement with the BPF. Right, which has always taken place since the JJB days in 2009, and they've become a key feature, to my mind, of ensuring fairness to landlords. I mean, the key point the termination right is seeking to support is the one of the CVA being required to provide a better outcome than the alternative insolvency process of administration or liquidation, and it's relevant to point out that when we're coming up with this outcome in these proposals, it's always based on professional advice and judgment. And what it's really doing is providing the floor to what is going to be offered to landlords. It's what is the alternative in that darker scenario. So the CVA outlines the deal, but it's also saying, if for some reason you don't like this, and we understand why no one really likes it, you can take your property back. And it's worth looking at that return. If you go back through any kind of statistics, the returns to unsecured creditors generally in administrations and liquidations are statistically very low, right? And that's particularly the case in retail and leisure businesses. And I know many landlords will have felt the pain of a tenant code going to administration and liquidation. Now, landlords will also know that the property world moves to its own timeline. So taking a property back and bearing the rates liability has its own risks and issues. However, on the CVAs that I've done, I've seen landlords take properties back in every case. All right, so it does work. Of course, if every landlord took their store back, then there wouldn't be a business. But that's also the gauntlet I think that the retailer has to run in these scenarios. But it's worth just making the observation on the flip side. We are talking about distressed retailers, and it's very hard for a distressed retailer to get its ordering cycle right when it's typically having to lodge orders 2 seasons or let's say 6 months in advance with its supply base at a time when they don't have any certainty over the size or scale of their store portfolio. So there's a real complexity there on the other side of this. And I know Simon will come on to it, but when landlords are exercising their choice, they'll be recognizing the availability of space and versus the demand for space in each of those areas. But I think it's one thing I would just want to point out. I really do think it's a fallacy that the segmenting of landlords is into what bucket or category they sit in. It's all about the context that it's all about what you need to do to get the vote through. It's just not right. The guiding principle here when we're looking at CVAs is always business survival and what is needed. These businesses are in the A&E ward, so survival is the guiding light for presenting a deal to the various stakeholders. And I can tell you that in my community, for every possible CVA candidate I look at, 1 in 3 isn't a candidate for a CVA. It's just not. And that might be because the voting won't work or because it's not going to produce the results, or actually, it's not the answer for the business. So not everyone runs along to a retailer and says there's got to be a CVA.
Some really interesting points, Richard. Just going back to the termination rights, I think it's fair as long as it works, as long as we're in no worse off position than admin. When we talk about termination rights, typically we don't get long enough. We get a very short window, and for a landlord to serve the break, to get the paperwork together to serve the break, whilst that's in the background, what's going on is you need to remarket the unit and enter into a new lease with an occupier. And in the short-term window that we have, it's very, very difficult to do. If we serve the break, we are immediately taking back the space with the rates liability. And actually, admin, you get longer. So you're getting the space back, but the lease is with the administrator. You get some time to get your affairs in order. So I think I keep repeating the sort of the fairness point of view, but I think what I'd like to see is on the termination rights some more time, to give landlords the opportunity to make that decision. I go back to my point then that if we are serving breaks and we're then told, this has happened to us on a number of occasions, we can afford the rent. We put it in a Cat C, we halve the rent. Actually, we can, in this store, we can pay the full rent. That's extremely disappointing. What's happened? Who's advised? Who's looked at the ERVs? So I think, lease modifications, they're unfair if they go to term of the lease rather than the CVA. They're certainly unfair if the rent is lower than the ERV and the work hasn't been done. And this gets back to, Richard, where you get feedback from us that it does look like a stitch up. It looks like that landlords have been put into pots just to manipulate votes. And we want to just see some clarity on how stores have been put into categories, so we can go into this together, understanding that the rent needs to drop to make sure that this business survives at the very outset. And this is the problem that we had during the raft in 18 and 19. We weren't convinced on a number of occasions. There were tenants, there were occupiers making money the year before, making a profit, and then all of a sudden we're being told that they are heading into insolvency, and not everything we were being told stacked up. So,
and I just say, look, and I can sympathise with that, because actually I thought the CVA that I looked at and I had concerns about it was New Look number 1, right? Because I don't think the operating business would ever have gone into insolvency at that particular point. So.
Thank you. So I think in answer to the question, picking the threads out of that one, the limit or the minimum deal that can be offered is one that enough landlords are prepared to take. Is that a fair summary, or short summary? Okay. So I'd like to move on to the voting discount for landlord's future rent claim, that the 75% or the 25% or perhaps the 50% discount. I'm sure this is something our viewers will be very familiar with. So this was another area where the landlords had some success in New Look and Regis, was in relation to this uncertainty discount, which is applied to the landlord's future rent claim for voting purposes. I'm sure you'll be familiar that the landlord's future rent claim for voting purposes is calculated based on the formula applied to disclaimed leases in a liquidation. And broadly, it's the whole of the future rent due under the lease mitigated or reduced by the amount the landlord is expected to get by reletting the property, or would be if they did relet it. However, it's been custom since the very first CVA to apply an additional uncertainty discount to this number. Originally, the discount of 75% was adopted and adopted solidly for about a decade, which reduced the value of the landlord's future rent vote to a quarter of what it would otherwise be. Since the Debenhams decision in 2019, and perhaps since tenants have been doing more store-by-store analysis on the local market, this discount has come down. Last year, it was common to see discounts of 25% and 50%, thereby increasing the landlord's future rent vote by 3 times or 2 times, respectively. So can I aim this question at Julie? Can you tell us what the cases said about the practice of discounting the landlord's future rent claim? And then perhaps, Simon, if you could follow with your view on what we can now expect to see in future CVAs on this issue.
Well, in both cases, as he said, the judge considered the voting discounts applied to calculating landlords' claims for voting purposes. And in New Look, the discount of 25%, the judge didn't find that was unreasonable or unfairly prejudicial. He didn't have to decide the point, but he did make comments that the blanket discount of 75% in Regis would be unreasonable. Now, the starting point for landlords' claims for voting purposes for unascertained or unliquidated debt, so i.e. their future rent claim, is that they're valued at £1 unless the chair decides to put an estimated minimum value on it. Now, the duty of the chair is to consider any evidence that's put to him or her on the level, on the formula and on the level of discounting that's included in the formula. The judge said in New Look that there was inherent uncertainty in valuing a claim. It's not an exact science, but a discount, he said, in that case of 10, 20 or 25% wasn't necessarily unfair, and was used in New Look. A discount of 25% was taken as a proxy to find the lower end of the range of values for calculating the or deciding the estimated minimum value for the purpose of the claim. And that he said wasn't was consistent with his duty to place an estimated minimum value on the claim. So the difference in Regis was there was a blanket discount of 75% where that had been applied against all landlords' claims without any consideration of the position on a lease-by-lease basis or store-by-store, which had taken place in New Look with the aid of expert evidence. So the blanket discount of 75% would have been unfair if he'd had to determine that point. So I think we can safely say that the days of 75% are well and truly over. I think the other point that the judge made was that a 75% discount was very high and it would have to have adequate justification, but there was no justification at all put forward in terms of Regis, except that this is what had been done for many years previously. Well, that wasn't considered to be any justification for a discount of that level. And I think the reality is, in any event, that we've seen over the past few years, the discount has come down as I think landlords have banged that drum and companies have taken on board challenges, etc. And so I think that we have seen discounts being reduced to the levels you've just mentioned, Inga. I think it's highly unlikely, to my mind, that a company would put forward a discount above 25% and risk a challenge on that ground in the future.
Thank you, Julie. Briefly, if you will, Simon.
I mean, I totally agree with Julie. I think the days of 75% are gone. That to me is just one thing, justification for landlords challenging CVAs. We've been saying it for a number of years to try and explain to a client why is their claim being discounted by 75, and the answer that we get back is, well, it could be £1. You just can't explain that to anybody. So I agree, 75% is gone. It's now no more than 25%. Is that fair? Possibly.
Thank you. So moving on to the Virgin Active decision. Now, so Virgin Active, as everyone knows, ran a chain of fitness clubs. It was also severely affected by the pandemic and came close to running out of cash in May of last year. And instead of proposing the familiar Landlord CVA and perhaps a parallel scheme of arrangement, as New Look did, to compromise its finance creditors, Virgin Active chose to make use of the very new procedure called a restructuring plan, which came onto the statute books in June last year. So this is one for you, Richard. Can you tell us very briefly what a restructuring plan is and how it differs from a CVA, which attendees will obviously be much more familiar with? Perhaps you can also cover why Virgin Active used a restructuring plan rather than the CVA, and what happened to the landlords in Virgin Active.
Okay, thanks, Inga. Yeah, so I mean, restructuring plans were introduced last year for the very first time into UK legislation, and they were introduced because a combination of corporate Britain, the government, and the restructuring community had recognised the need for another heavy-hitting corporate rescue procedure. And that's because when administration was brought in back in 1986, it was designed in theory to promote the going concern survival of legal entities, and it's singularly failed to do so. So there's been a glaring need for another process. And so what the restructuring plan generally does is it moves us along from administration much more towards the Chapter 11 procedure that is the mainstay of the US corporate rescue toolkit. And that's all about corporate survival and what we call the debtor staying in possession. So if we look at some of the key aspects here, so voting is just as key here as it is in CVAs. There's actually creditors and shareholders all get to vote in classes according to the similarity of their rights, both before and after the restructuring. And whereas, and we've covered a little of this before, where CVAs are an effective tool for operational restructurings, and we've said they can't compromise secure debt or equity, restructuring plans enable both the financial restructuring and the operational restructuring to happen in one go, as they can compromise equity and they can and do compromise secure debt. So it avoids the need for a scheme of arrangement, and effectively you have one process that can deal with all the aspects of the restructuring that a particular group or entity might need. So some big differences though to CVAs. The restructuring plan has heavy court time. It needs to be sanctioned and approved by the court. And this changes a number of dynamics. It makes the whole restructuring process more expensive due to that need for that court involvement, as well as having the creditors meeting. So there's a big layer of additional cost that goes with the restructuring plan, which is why it lends itself more to larger businesses just because of the cost barrier. It effectively bakes in an objection process at the court convening hearing. But what that does do, though, it actually is a shorter timeline for an objecting creditor to get their act together, to say, I don't like this, than what you might get in a CVA. What it does do, though, because of that, it gives a much greater certainty of execution, because once the court sanctions the restructuring plan, then all the stakeholders have to live with the consequences of that. It means that the business can then move on and people know where they stand. Restructuring plans provide for what we call the cram down of a whole dissenting class, provided that class is shown to be no worse off in the alternative. And we've already seen that now happen in restructuring plans. So and also I'd say a big thing I really want people to bank here is that the voting threshold versus CVAs is easier to meet in a lot of different circumstances. And the rationale is that in CVAs, they have this term called connected creditors. And connected creditors are things like intercompany balances and employees. They can vote, but they can vote in CVAs, but only in respect of what we call the 75% test. There's a second test in the CVA that says you still need 50% of the non-connected creditors to vote for it for a CVA to be approved. In a restructuring plan, that test does not feature, right? So, and it's highly normal in the larger groups that I look at for there to be some very large intercompany balances kicking around. And I can think back to some CVAs that I've been involved in that would have been carried if that second 50, just by the intercompany debt, if that 50% test hadn't been there as a safety check for landlords. But that's not the case in restructuring plans. So where there are big intercompany balances and big connected creditors, that is certainly going to make it easier for the entity to have a restructuring plan approved. And again, if we turn on to Virgin Active, and maybe that's a lead into what happened on Virgin Active, because if you look at the way the landlords voted, all but one of the landlord classes voted against the restructuring plan. So what that tells you is if they'd chosen a CVA as the mechanism for that restructuring, it wouldn't have been approved. And yet in Virgin Atlantic, it was approved because of their same dynamics. And so I think what that already means is, and it's not good news in terms of the concerns that landlords have, but what it does mean is there are now two restructuring tools that can be used and they're not, restructuring plans aren't exclusively aimed at landlords, they're being used across a whole raft of industries, which is a good thing. But actually it just means that a struggling retailer or a leisure operator has two tools to look at and can choose between them moving forward.
Thank you, Richard. We're running a little bit behind, so perhaps, Julie, I can ask for some quick thoughts, real estate reaction to the restructuring plan being used for landlords.
Well, I think certainly the landlord clients I've spoken to all consider it to be something that is like a CVA on speed or something of that nature. But I think the point there is that two things: if the company can't get the votes that they'll need to get a CVA through, which was a position in Virgin Active, then they're going to be looking at restructuring plans. As Richard said, it's going to be much easier for companies to get a restructuring plan approved, because they can arrange the classes of creditors that are voting to make sure that they can engage the cross-class crown down by having, the intercompany creditor, the secured creditor, whatever, in one class who's going to approve the plan, and have landlord creditors in different classes. Even if they dissent, then if the conditions for cross-class crown down are satisfied, then the plan can still be sanctioned by the court. It's clearly evident from the case that if the landlords or other unsecured creditors are out of the money, then it's going to be very, very difficult for them to challenge on the cross-class crown down, and even on sanction, that their objections will have little weight.
Some food for thought there. Thank you. Let's move on to the topic of disclosure. We'll try and cover this quite quickly. So the subject of disclosure and transparency cropped up in both CVA cases and in Virgin Active. And I know this is a topic which landlords have complained heavily about. So in the Virgin Active case, the ad hoc landlord group demanded disclosure of a great deal of information, some of which was commercially sensitive. And in the end, the judge did grant disclosure to their legal advisors, subject to a suitable confidentiality undertaking having been given. And then the legal advisors could then summarise the information to landlords. So, I mean, disclosure is a very difficult topic. The CVA proposals already run to hundreds of pages, and yet landlords frequently argue they don't get adequate disclosure of the right sort of information. So, Julie, how do you think disclosure is going to work in the next round of CVAs and restructuring plans? Well,
as you said, it was a major issue in all three cases. I think one point I'd make there is that on New Look and Regis, even in the limited respects in which the court found that disclosure wasn't adequate, there was still not a material irregularity, even though there was an irregularity. So basically the disclosure of those documents wouldn't have affected the outcome, and so it's not material. I think that makes it very difficult, and it's quite, it almost encourages companies to withhold information that they think they can get away with in terms of the CVA proposal. I think it's for landlords that are really going to have to focus their efforts on scrutinising the information they get on day one of launch of a CVA or a proposal, and make sure they really hone in and narrow down the documents they need, why they need them, think about issues of confidentiality and how they can address them, to make sure, if anything, they have at least a paper trail and the evidence to make applications to the court if the information isn't provided. Because I know it's a massive bugbear for landlords that the lack of disclosure and the information that they really need to assess the plan or assess the proposal for voting purposes. But it's a challenge because we're talking about very compressed timescales. And I think they just have to be geared up to really, identifying what are the key documents that they really need to have.
So Richard, if I can ask a very brief response from you on that one, do you think there's work to be done for tenants on sort of working with landlords on disclosure?
I think there is, and I think the tenants just need to respond to the drumbeat. But the one thing I would just land as the complex point. So if you look at your average 300 store retailer, there's probably 150 landlords making up that portfolio, right? So how do you go to 150 landlords in that time frame and have that type of engagement? It's very difficult, is all I'm saying to you. So it is trying to find the right balance, and I think that the judiciary haven't come down and prescribed something. But what they have done, though, is give everyone a helping hand that says, you know what, you're going to need to do more than what you've done. All right, so that has to be a good step.
Thank you. So I'm going to move on to the sort of crystal ball gazing and what sort of tips for the future. Let's take stock and look at next moves for landlords. We know that these court results have not been universally welcomed, but they do provide some welcome court scrutiny of the CVA process. I think we can all agree on that. And this is something which the judge referred to expressly in the recent Cafe Nero decision as well. So landlords have a better understanding of what to expect from these restructuring procedures, particularly the restructuring plan, and how they're supposed to work as we go into an economic period, which is forecast to involve a good deal of restructuring to help COVID-affected businesses survive. Landlords are a significant stakeholder in these businesses, so what should they do? Julie, how do you think landlords might proactively seek to engage with tenants ahead of restructuring? And perhaps, Richard, you can come back on that. So, do you think we're going to see increased and meaningful engagement between tenants and landlords?
I think that, that is something, obviously, first of all, I'd say most landlords do know what's going on with their tenants and, are willing to talk to them. And I've certainly seen lots of cases where it's the tenants who are refusing to engage. But I think landlords have to make that effort to try and reach out to them and engage with them and make sure, again, that they're keeping a paper trail and evidencing that, so that if they don't get anywhere and then a CVA or a plan is proposed and they need to make applications to court or whatever else in terms of supporting their evidence in terms of any objections, they have that evidence. But the starting point has to be, if your tenant is struggling and they'll know that because they're not paying the rent, then there needs to be that engagement. And we all know that there's going to be obviously the outcome of the moratorium being lifted and the government's call for evidence on the approach to how COVID arrears will be ring-fenced, etc. And I think that's all part of the need for there to be engagement, if there can be, rather than face potentially a bad situation in a CVA or a plan or other insolvency.
Richard, do you think that's feasible? Do you think that's going to work?
I don't think so in the short term. I think it'll be easy to find examples. I know I can, where I can say that corporates have gone to landlords but haven't had any success in terms of getting what they need. And I'm sure landlords have similarly tried the other way and not had engagement. So wouldn't it be great if there was the Neville Chamberlain piece of paper that went up and said, here's one we've all managed to do outside of a process. So I think that is the challenge. Now, as a restructuring practitioner, I can't make that happen. But I think the way you've got to make it happen is in that medium long-term play, is you take other stakeholders that get around the table earlier and faster. It's because their contractual documents require the provision of information, and they have access to information, and they're contractually enabled to have a different style of discussion. And I think that's maybe something we should start to see in leases as they move forward, if landlords are up for it, because I think that's what will it's that contractual nexus around that should drive that type of dialogue.
So, Simon, if I can ask you, having sort of seen these decisions and understood the impact of them, do you think that your approach towards tenants or struggling tenants is going to change any?
Yeah, I mean, I think, our experience during the pandemic is, the good thing that's come out of it is we've all, to speak for lots of landlords, never been so close to our tenants, to our occupiers, to our partners, speaking to them, helping those that genuinely do need help, understanding their business. We understand, the cash flow, profit and loss a lot more, and there's been an open dialogue. I would love to see that transparency at the early stages of any restructuring. We haven't in the past. We asked lots and lots of questions, and this is where we become slightly suspicious, where I can only recall one particular CVA proposal where the landlord was the only creditor, where we were invited into a room, files were open, whatever question we asked, we got some information back. We don't receive that often. We don't have much time, and we do need to understand. We go back to, I'm trying to understand who's sharing the pain, because at the moment we're sat there as landlords thinking, why are we picking up the bill here? As I've said in the past, we need to understand the valuation of a business, profit and loss of each store. Why have we been allocated our lease into this category? Understand it. So I certainly hope that lessons learned from CVAs and the challenges that I think have been necessary, if we can come out of this, we do want better disclosure, greater transparency. I would just say on the restructuring plan, I do have a fear that because of the challenges and I see Regis, in my view, was a success. It was revoked. Does this mean that the insolvent, maybe a question for Richard, the insolvency world, do you move away from CVAs because you fear a challenge and move towards restructuring plans? That's my concern.
If I just pick that up, I think it's worth understanding what our role is, right? So, and the role of a restructuring plan is that economically, politically, and societally, the UK has decided it needs this process, because what it wants to do is to have a mechanism whereby more businesses survive that have been struggling. And what that means is it's a mechanism whereby people will take pain, because that's what goes hand in glove with that. So actually, when we're looking at, we just look at the tools that are in front of us, and our objective here is to try and have the business survive. So we'll choose the tool that with all the dynamics in a particular case, we think is going to get the best chance of execution. That's really where it comes from. It's not designed to stitch someone up or to manipulate. It's about how can this business survive. That is the essence of it. And it's just a consequence of that people take pain. I think restructuring plans will be used. It's a tool that has more certainty, but it's much more cost. So you're not going to see this being used very often at a 20-store retailer, because they won't be able to bear the burden of the cost. I think where you will get, though, is you get some middle market businesses where, whilst this is expensive, if we think the restructuring plan gives us the certainty of execution, we'd go that way, whereas otherwise we would have gone a CVA. And taking what I've said at face value, if there is that big connected creditor vote coming down there that can enable this to go through via a restructuring plan, we can't have a CVA, then the choice becomes obvious.
Thank you, Richard. And picking up on one of the comments that Simon made about looking for sort of store valuations and P&Ls and things. Julie, perhaps we can look at future leases. We've seen a sort of wholesale change and switch to turnover rents, and that's obviously going to take a while to settle in and impact or develop the relationship between the leasehold relationship between landlords and tenants. Do you think that there might be provisions or information provision obligations going into new leases and rights that landlords might usefully include in lease agreements to support turnover rent provisions?
I think it's, if there's going to be inclusion of turnover rent provisions, then obviously that has to go hand in hand with provision of certain information, because the company's got to provide that information in order for the level of turnover rent that's due to be assessed. And I mean, even within CVAs, you'll see a whole mechanism for provision of certificates and so on that support the turnover rent that they're going to pay. So I think that's clearly something that has to go into leases if there's a turnover rent. I think there's sort of separate considerations then around maybe the more general point Richard was making about the provision of information, and you know, whether in leases going forward landlords negotiate with their tenants and agree provision of financial information metrics that they can perhaps it is going to be linked to something like a performance break for landlords. So there will be you know, provision of information to see whether or not the tenant meets particular financial metrics that it's agreed to. But I think this, because it's got to be, I think, a wholesale look at the sort of structure of the landlord and tenant relationship and the lease that sits under that with these decisions.
So perhaps landlords will need to sort of move towards more of the model for finance creditors in terms of information provision and monitoring to sort of monitor the financial health of tenants going forward, or big landlords perhaps. I think that'll be quite difficult for little landlords or medium landlords. Okay, let's turn to, we've had, I think we've had 3 questions, and thank you very much. So let's take these ones. So Mike Jervis, thank you. There are many examples of CVAs failing after approval. Does the panel think that an absolute prohibition on the CVA supervisor becoming the subsequent administrator may produce more robust CVAs ab initio and assist on the perception point? Well, who would like to take this question first? I think I probably need 2 answers on this one.
Well, should I go first? I mean, I just think it's irrelevant. I just don't think it's a point for consideration. I think the issue, we never put forward a CVA with the view that if it fails, we'll pick up a job. I think that's just not the right commentary. It's all about business survival. But I go back to the point I made earlier. These businesses are in the A&E ward, which is why, regardless of a CVA, some of them just won't get through. And that's because actually dealing with the leasehold issue is just one of 6 or 7 points that needs to be dealt with every time you do a CVA. It's the proposition, it's management, it's equity, it's debt, all those sorts of things. It's just not a consideration for a practitioner, or shouldn't be.
So perhaps either Simon or Julie, but accepting that if you were going to adopt this proposal, there would be an increased amount of cost, because of course, if you've got a supervisor that in a failed CVA that becomes the administrator, they will have familiarity with the business. They'll be able to sort of get up and running straight away. If you have a new insolvency practitioner come in, there'll be an element of sort of duplicating cost as they get up to speed. Is that a price worth paying? Do you think this would provide some comfort to landlords?
If I can answer, Inga, I mean, I think that the point there is that would it mean that the original nominee and supervisor approaches a CVA in much more carefully? And I hear what Richard says, but I think we have the likes of Regis, where we know there was potential issue around the nominees' approach to the CVA, and it didn't consider all of the points it should have considered when it put forward that CVA proposal. And I think that's where the question of whether or not they should be administrator afterwards. There is, of course, additional costs, but would it mean that the initial proposal is even more carefully thought through? Now, Richard would probably say, and I expect most IPs would say, they've got to do their job properly, and that's what should happen and does happen in the majority of cases. And that whether or not they're administrator following a failure of a CVA, it doesn't matter. But I question whether or not that would encourage more robustness, as Mike has suggested.
Simon, do you want to come on that one, or should we? Yeah, I absolutely agree with Julie, and Richard said when these things are proposed, that administration shouldn't be actually at the sort of, well, we'll try this, if not, then we'll move to admit. The whole point of it is to prevent administration. But I agree with Julie's comments. Okay. So this is a good one, given that we're a BPF webinar. Given that landlord-tenant engagement at the earliest stage is key, where is the BPF in all of this? Why is the BPF not front and centre at a very early stage? I think those of you that are sort of on BPF committees might be able to respond to that one. We're heavily involved with the BPF. I sit on the retail board, and I disagree. Actually, I think they are front and centre. They're immediately commenting on CVA proposals. They have been heavily in watching the challenges and have been the voice of landlords and getting across, often government and the press, they want to really sympathise here about the landlord, but actually what the BPF do very well is remind people out there that this is your pension funds, this is person on the street, these are local authorities, charities and so on. This is why it's important that the landlord gets treated fairly. So I think they're doing a good job voicing all those concerns. So
we're coming close to the hour. I would like to give each of you the opportunity for a closing sentence or two, really just a sentence or two, to sort of sum up, where you feel we are on landlord CVAs and perhaps what you might expect from the next few months. Richard, do you want to go first?
Yeah, look, I mean, it's an interesting one around CVAs just because of the level of landlord arrears, right? And so I think voting and all those sort of things are going to be interesting. I think the challenge for landlords is going to be how do they really react to the fact to those tenants that haven't been paying their rent, and how aggressive do they go in terms of recovering. So I suspect there are some folks out there that should have been paying their rent and haven't been, but how hard do you go in what's going to be a very fragile environment? So I think we'll start to see an erring towards restructuring plans. Is what I think will happen, just because they're going to be easier to get through, and so that's what I see.
Thank you, Simon. If I could keep you closer to two sentences.
Yeah, I think it's is time being called on CVAs. We're concerned about the misuse of CVAs. I've said before, I think it's right that landlords are challenging, because it's now there's a steady stream of CVAs as we've seen, and we can't just stand still and let the system be misused. So I certainly think it's right that landlords are challenging, and something does need to happen. I'll be disappointed if that means, and I think Richard's answered it, that the alternative from a CVA is you move on to something else. That is not resolving the problem, the concerns that landlords have got.
Julie, last word from you, please.
I think, regrettably, we are going to see a lot more restructuring plans for the very fact that, the COVID arrears mean that tenants won't be able to get CVAs approved because the landlord vote may well swing it. And, despite the cost, there is the certainty aspect of it. So I think that restructuring plans will now come to the fore. I don't think CVAs will go away for probably some SMEs. And I think really for landlords, it's thinking about the engagement aspect with their tenants and the collaboration with other landlords, because that's where I think the pressure of the timing, the cost, the resourcing for really dealing with plans or CVAs, it really helps if they can collaborate and pool that time and resource.
Thank you so much. Well, we're up to time. I'd like to say a big thank you particularly to the BPF team who's organised this behind the scenes, and especially to Richard, to Simon and to Julie. You've been a really excellent panel. Thank you very much, and I hope that attendees have enjoyed it too.